Welcome to the LaunchPreneur experience. Right now, we're hosting our second series, and that is the Legal Edition series. My name is Fernanda Furman, your host. I am a launch and summit strategist, also an international speaker, and I have a love for supporting people in their business and bringing topics and conversations that can support them creating a better business and also understand what happens beyond their limitations. So today I'm here with Jay Razzouk, and Jay has been a speaker in another event that we had. And I just love everything that we talk about behind the scenes and how Jay and his wife, Wendy, has been supporting their clients with legal contracts and really bringing awareness to topics that we don't even think about until something bad happened. So thank you so much, Jay, for joining us. And Jay is going to be talking about the 3 costly legal mistakes most entrepreneurs make when hiring independent contractors. That would be me. So I can't wait to learn from you. Thank you so much for joining us, Jay.
Thanks for having me here, Fernanda. And definitely I'm excited to dive into this because I know you probably have a lot of amazing stories to even relate to what we're going to talk about.
Yes, that's true. I think all independent contractors have, right? So, and also people that hire, because even as an independent contractor, I also hire independent contractors to help, to support our business. So yes, I would love to hear what you have to share. And what are the things that you see the most in your practice, Jay, that could have been avoided by having a contract in place?
Usually just the number one problem about not having a contract in place would be just the ambiguity or the uncertainty as to the expectations. When you don't have the contract, it's hard to say you really have an agreement that your mind and their mind are on the same page. So now when you're guessing, okay, well, they said this, I said that, and there was this email. Now it's just you're in a zone you don't want to be, and it costs a lot of money if you have to pay a lawyer to put it all together. So definitely you don't want to be in that stage. And I say contracts are more about establishing the expectations, and good expectations are the key to a happy relationship. So that's the first part of it. And then there's another aspect to it where if you don't have a contract at all, you're also going to run into issues of basic legal issues of like there's certain things which need to be in writing. And when it comes to like, we'll talk about it, like intellectual property, if it's not in writing, you're going to have some potential big issues down the road. So have in writing, be clear on your expectations, and have a much better relationship as a result.
Yes, I totally agree with you. So what would be those 3 mistakes that people usually make?
So when it comes to independent contractors, the 3 big mistakes I see would be 1, misclassification of a independent contractor when actually they might be more like an employee, and there's huge ramifications for that. The second mistake will be what I mentioned, intellectual property, and not really properly spelling that out in the contract. And then a third very common mistake I see is putting in terms that are just outright going to be unenforceable, usually regarding like non-compete and non-solicitation. Like everybody always wants that in their agreement. I hear clients all the time come to me saying, just yesterday, hey, I want an agreement that has this, this, and this. I want to make sure they can't ever compete with me. We'll talk about issues with that too. So those are 3 big things I think every person hiring entrepreneurs needs to be aware about.
Oh my gosh. Yeah. So as you were going through that, I was already thinking about situations in my own business where again, expectations were not set correctly. And, there's as you said, there's the emails, even how do we solve the problem if a problem arises, right? Like how can you actually solve that problem? Now, one thing that in California, for example, if you do work, depending on the kind of work you do, if you do work more than once for a person, you could be considered an employee. right? So I would love for you to explain that, because an employee would be somebody that does work constantly. But on the other hand, if you're hiring a contractor that has work with other coaches, or let's say other, business owners, then where's the fine line? Does that different per state, or is just, one law for every state?
That's a great question, because that is the issue. There's no one definition of employer versus independent contractor.
Mm-hmm.
It's different state by state. It's different even by area of the law. So even in federal law, if you're talking about taxation, there's one definition. If you're talking about health insurance, or if you're talking about some other area of the law, different definition. So every single law rule might have its own definition of what an employee is. And then this is where then lawyers have to help you navigate it. But I've broken it down to 10 basic principles. If you follow those principles, you're going to be generally safe. We probably don't have time to cover those, but they are, if you know those and follow them, you should be generally safe. Now, let's talk about the three big ones. The three big ones that, especially if you're hiring people in California, you need to know about. And actually, California and New Jersey both follow a similar test. And in California, if your independent contractor, quote unquote, has any one of these three things going on, California will say they are an employee. So what are those? So the first one is there an absence of control? If you are doing too much to control that person, you're setting the times when they work, you're saying where they need to work, you're telling them how they need to do it, you're training them, you're just all these things. If you do too much of this, eventually California will say, okay, they are your employee. And I see this so much. Probably most contracts, independent contractors I see, they are doing way too much in terms of control, and really putting themselves at risk. Not even in just California. I say a lot of states would probably, if they scrutinize it, would say, yes, this is really an employee. So
and that would be like, you need to be at this job at this time, and you need to know these tools, and you need to bring or drive my truck, or
that makes it even worse. Yeah, it's even worse when you say, okay, I'm going to provide you your email, I'm going to provide you your computer, I'm going to provide you your phone, or whatever. You start providing them what they're going to use. That also now puts you much more in the employee zone. So yeah, there's a lot of these factors, and definitely let them pay for everything, have them supply their own goods, have them set their own times. Don't micromanage them. The idea is they're supposed to deliver a product to you. You say, I want this, they go away, and then they come back, here's what you wanted. That's kind of what the law is expecting for an independent contractor.
Even on repeat, even if they do that like on repeat?
So repeat isn't so much of a problem. The problem is going to be, and this actually jumps to the third factor. So we'll go there. So the second one is what they're doing different than what you do in your business. So this one especially is a bigger issue in California, maybe not so much in other states. So for example, you help people put on summits. So if you hire someone then to help with the social selling, the law might say, okay, well, that's kind of what you do as a part of helping people with summits and with their launches. So that might mean they're going to be an employee, just that by itself. So for example, for me as an attorney, if I hired someone as a paralegal, they're sort of in the same line of help as what I'm doing, they might be considered an employee. Or if you have a media production business and you want to outsource someone to do video editing for you, well, that's kind of what you do. Now, a way to get, when they're not in the same line of business, the example is always given would be, for example, you have trouble with your plumbing and you're not a plumber. You're your media production business. You help people with launches, whatever. You're an attorney. That plumber is completely different from you. They are totally going to be an independent contractor, assuming you don't hit any of the other tests.
Okay, that makes sense.
Yeah. And so that one's really tricky. I think this is where a lot of people also end up having their independent contractors technically becoming employees. Now, the third one, I think, gets closer to what you're talking about, which is basically, are they a standalone legit business? Like, have they already been in business and they're already serving other clients? Ideally, do they have an LLC or corporation and they're licensed and, really they're serving you and a bunch of other people in the same way? Whereas I have seen clients where they want to take someone who does one particular job and then wants to cross-train them, make them do this new job for them and only them. They're not going to be doing that for anybody else. And then work maybe like 20 hours, 40 hours a week. That doesn't seem like they're their own standalone legit business. And just by virtue of that, again, that would render them an employee in California.
Okay, now does that work? Is that the same? Let's say a lot of the coaches, a lot of people are hiring people in different states, right? And or in different countries. So what happened when you hire somebody from a different country? How, is that also considered an employment if that person is working, for you constantly?
Boy, when it comes to international, that's
Different.
But basically, the end of the moral of the story is the law of the state where that person is located probably is going to be the most applicable law. And there's not a clear answer, but basically, you could be located in California, but if that person is in New York, be more worried about New York law.
Okay, that makes sense. Then in that case, people would start hiring people from states where they are a little bit more loose in terms of if you're doing online business. Now, if you're doing a physical, if you have a brick and mortar, that would be a different.
Yeah, you can't get around it. But
yeah, I can't get around it.
I tell all my clients, like, try to hire people in Texas and other states where, it's a lot more flexible. Don't hire anybody in California. Don't hire any independent contractors in California.
With exception of me.
But you have a legitimate standalone business supporting a lot of people. They're not training you. They don't control you, right? So you meet the test.
Yes. I love that. And so what would be the third?
And maybe before we move on, I just want to emphasize it's so important to make sure you don't misclassify somebody, because if you treated someone as an independent contractor and later on, let's say you have a dispute and then they want to go sue you, they're going to, I see there's tons of cases all the time about this. They'll then say they were an employee. You maybe didn't pay the minimum wage. You didn't provide them unemployment. And that's what often happens too. If you part bad ways, then they might file for unemployment, say they really were an employee. You hadn't paid into the employment system. Now you got to pay penalties and all these things. You want to make sure you do it right up front, or else it could get pretty costly real quick.
Yes. And I see where, why this law would exist, because when I first moved here from Brazil, I was working in Los Angeles. I had somebody that had like an architecture office that was like a sweatshop. And in the end, I didn't sue them, but two of the other employees sued them because they were working full time. They were not getting any benefits, and they were moving, around in the company by doing different things so that the title would change. Every month, the title will change so they would get away with it. And because we're all from different countries, we didn't know the law. So I see where that would actually protect us in a way that we don't get taken advantage of. But
that's why it exists. It is to prevent people from being taken advantage of. And for those of you, again, who aren't comfortable with the difference of, what's different between an employee and an independent contractor, like when someone's an employee, they get a lot of benefits. There's a whole lot more legal protection for them. And there's whole agencies where, like, if they say you mistreated them, they can go file complaints. There would be investigations and all that. So this is why when you're starting off, usually it's the best strategy to work with independent contractors because it's cheaper. There's less regulations. less headache, less risk. But I'm just flagging to you, just because you think you have a contract that says they're an independent contractor doesn't mean the law is going to respect that. Doesn't mean a court is going to respect that. So
yes, great insight. Thank you so much for talking about that.
Right. So problem number 2, want to go talk about that one?
Yes.
All right. So this was about intellectual property. And I don't know if you've heard this one, but well, I mean, you are, okay, you probably do know this. You know, it's good to spell out who owns what when you're producing content for people. So do you say that you own the content, or do you say like the person making the content owns it? Or sorry, the person that you're making it for owns it?
So if it is my idea, I own it. Now, if they're paying me to think, and that's the part that I have a hard time with, like they're paying me to produce this and it's under their direction. For example, I wanted to have this way, or that way, then I would let them keep all the materials. But if I am the one that is coming up with the ideas and coming up with everything and create like an event that is unique, the idea behind the event, it's mine. They can repeat it, but it's my idea. And I don't even know if I got that, if that is right or not. Honestly, I am not protected. So I'm learning a lot from this event myself.
I was curious because I think what you explained, I think, is probably the starting point of what a lot of people would expect, right? And this is where people's expectations versus what the default law might be is going to be probably potentially different. So the default law is when you hire someone to make something, if they're an independent contractor, they will be the author of that copyrighted content. So if they're writing scripts, they're editing a video, they're shooting photos, they're writing music, whatever it is they're doing, if they're creating a work, they are the author of that work. And by default, or at least initially, they will be the owner of it, of whatever they're creating, even if you paid them to do it. So this is where now you need to make sure your contract has the right terms in it to get the content they created from them to you.
Mm-hmm. Okay, that makes sense. And even like files that you put together on the back end, right? Look, say, for example, for me, I have like tracking. Like I am an Excel crazy person. Everything that I have, it's on Excel. And I create those Excel files to, let's say, track the leads or track the engagement. And that is something that I created, but I let the client use as part of the event. And I have seen, I saw one of my files running around, like just kind of I was part of another event. And I'm like, how did you get this? Oh, because I work with somebody that shared with somebody and nobody knew it came from me. It was my copy. It was like my file. And at that point, I was just like, you know what? I didn't have any protection, still don't have any protection on that. And it's just kind of trusting that people will respect the fact that it says, do not copy, share, or give it away.
Well, fortunately, you're the author, and maybe you'll have some rights there to it. But yeah, but the big exposure here too, though, is when you're hiring someone else, let's say, to make content for you, you're thinking it's yours. I paid for it. I own it. And by default, that is not the case. And so, I mean, think about Walt Disney. If Walt Disney long ago had hired somebody else to make Mickey Mouse for him, and they made all the movies and all that, get this. After 30 years, the person who, the original author, the person who first made those works, can take back ownership, whatever they had given you.
Oh, wow. But if you work as an employee, then it's different because you're inside of their company.
Exactly. So this is one of those few times where having an employee is much better. If you really want to make sure you have full ownership of whatever's created, you might want to make sure they are an employee. So there's a a little nuance here where have you heard the term works made for hire?
No.
Okay, so this is often put in independent contractor agreements to try to say, oh, everything that you make is a work made for hire, and therefore I'm going to own it because I paid you to make it.
Mm-hmm.
And
Which is
that
not even
usually,
applicable.
yeah, no, usually works made for hire only, that concept only works for employees. And there's some really rare exceptions to it, like if you're putting together a compilation. But beyond that, beyond those couple exceptions, most works made for hire only are when someone's employed.
Mm-hmm.
And in California, get this, California says if you say anything they make is going to be a works made for hired or works made for hire, you have converted them into an employee.
Wow.
So, and most
Wow,
independent contractor
that is a
agreements I see.
costly mistake. Let's talk about a costly mistake. If we could just put a bunch of red, arrows right now,
It's a big one.
It's a big one.
And most independent contractor agreements I see drop in that language. So yeah, if you just take some random contract, and if you're in California and you use it, or your independent contractor is in California and you use that, technically they are an employee. So this is why you really should have an attorney really review for you.
So is that the same way? Let's say I am a contractor and I'm giving my client a contract to sign because let's say they're hiring me to do their summit, right? Mm-hmm. So then let's say I have there that I am being hired like a work, for hire. If they sign the contract, it's that because it's not, the contract's not coming from them, it's coming from me. It doesn't mean that I like they are legally binded to this term, right? Because it's coming from me.
Sometimes a court might look at who drafted it, and if the other person approved, like that's not what I intended, I didn't even realize that, maybe they could get out of it, but you can't count on that.
Yes, yeah. So it's very important because as you're hiring, I didn't know that, and if somebody wants to really take advantage of me, they could give me like an independent contractor that's just doing my social media could give me something like that, and then later on come after me and just say, I was working for her and this here she signed. So it's so good to be aware of those little things that actually become big in the end, and we never know until it happens, right?
Exactly.
Wow, that's a big one for me too. I didn't know that one.
Yeah, I don't know why more people don't talk about it, but maybe it's because it's really a California niche thing. But there might be other states that have similar rules and you just don't know it.
Wow,
so
amazing.
It's definitely good to start off with a really good template and then have your attorney review it.
Yes, absolutely. And that's when you want to have a template, right? You start with the template, go through it, and then after you're done, then you have the attorney reviewing, because that's going to also save you, a lot of money, but also saves you a lot of headache as well. So.
Yeah, because when you buy that template, it comes with the instructions and some guidance. Whereas if you just rip it from your friend who's from another state, it might not help you. You might not know what's been taken out and changed. So
on that, I'm going to share something that Jay helped me with. I had a contract that I had an issue, and I gave it to Jay. And one of the things that you pointed out is that it was not, I copied from somebody else, a friend of mine, and she is, I think she's in New Jersey. And it says Commonwealth of California, because I just changed the city name. And then you mentioned, well, California is not a Commonwealth, right?
Yeah, we call it the state of California. And right there, I could tell, someone just took some template and changed the words.
And I was like, oh my gosh, busted, right?
I mean, it's not a major mistake, right? I don't think that would have legal ramifications, but for me, I was like, red flag. Oh, yeah.
But just that thing, just copying, somebody else's contract, just because she gave it to me, it was drafted by an attorney. it doesn't mean that it's right for me, for my city, for the laws that are happening here, right?
Mhm.
So
It's a great example.
yeah.
At least it wasn't a major blunder there.
Yeah.
So, all right, let's talk about the next and third major mistake. And this one I hear all the time, right? I hear all the time clients coming to me say, "Hey, Jay, I want to make sure that my client prevents people from competing against me. And, this person's going to see my customer list, they're going to engage with my customers. I want to make sure that they don't steal them, they don't solicit business from them." Great to have that concern. But usually most people think I need to do this by having a non-compete agreement and a non-solicitation agreement. Now, usually those are, when you look at templates, worded extremely, extremely one-sidedly. Like you can never, ever compete with me anywhere on the planet. And, don't even think about touching any of my clients ever. That goes way too broad.
Mhm.
Like probably anywhere that sort of clause will get shut down in court. Most states, the states are going to want to make sure that it's reasonable in scope, like geographically, and reasonable in duration. Usually, let's say 2 to 3 years. It depends on the nature of the work there, but they don't want to be forever and ever in anywhere on the planet. Yet that's often what I see in agreements.
Okay.
Just because you want something doesn't mean the law is going to respect it. And, we are in America. America likes freedom, and America wants people to be able to work for whoever, anytime. Like that's usually what we want to see. So the law is going to be very opposed to any restrictions on somebody's ability to work.
Yeah, and I think the hardest part on that one is that, for example, when I was working in this architectural firm, I really wanted to work there. But I knew that job was just a stepping stone to where I wanted to be in a couple of years. And when I went to sign the contract, somebody that signed the contract before me, they said, don't sign the contract because it says for 10 years, you cannot work for another architectural firm because I was learning, some kind of a specialty training that they were giving to me. And they said I could not work for somebody else for 10 years, like on the same, that were using the same techniques. And I was like, I can't, because what if there's so many what if situations, like maybe I'm leaving not because I want to, but because maybe I need to work from home from now on, and your company doesn't allow me, or maybe because there's some harassment inside of the company that, I need to leave. So or I'm moving too far away and I can't drive that much anymore. So now you're limiting my capacity and my brain power to get a job somewhere else just because you're afraid of me using my intelligence somewhere else. And I didn't get that job. I didn't want to get that job. But that's kind of how I understood why this law was important. It was like, I know I understand that, but when does it go wrong?
When does it go wrong? Like, why wouldn't you want to use a non-compete agreement?
No, I mean, when, like I understand that a client, like I could work for somebody, get all the clients and try to get, and try to get the clients for myself afterwards, like getting all everything that they use. Now, a non-disclosure, non-compete usually comes with a non-disclosure, right? Like you can't use their tools or whatever they're teaching you in there, right?
So exactly where you're going is where I wanted to go. So the way to protect your customer list and to restrict their ability to just take your customer names and email addresses and then go compete with you is to use that non-disclosure agreement clause. Or I mean, you could have that clause in part of the independent contractor agreement, or you could have a standalone non-disclosure agreement. And in there, you can say, my customer list, Their names, their emails, all these things are proprietary information. They're a trade secret, and you cannot disclose it to anybody else, and you can't use it.
But you would still have to put a date, a due date, right? On that they know, like for 2 years.
Yeah, ideally you need to put a limit on it. I mean, for me, for example, I'm just, hiring somebody else to work for me as a lawyer. My duty to keep my client's information confidential never ends. Therefore, anybody who works for me, they also should never lose that duty to keep it confidential. And that's a rare situation. Most people, a court again is going to say, we don't like restricting speech. So we want to make sure that you have a reasonable time frame on how long they have to be silent and not use that information. So that's where, again, a lawyer usually needs to think about, okay, what is a court going to want here? What's going to be reasonable? And you can't just say, 10 years. That might not hold up.
And is that the same for an employee and for a contractor, or it's different?
There could be nuances. Like in California, usually it's the law is going to be a little bit more opposed to restrictions on employees. But at the end of the day, I think it more or less it works out to be about the same.
Okay.
In this regard. And I'll say in California, yet another reason why not to hire people in California. California outright says any non-compete agreement and anything that looks like and acts like a non-compete agreement is invalid.
Oh, wow. I notice you always say in California. It's always like this, but in California. But in California.
It's the way of things. You have what most people do, and then there's what California and maybe sometimes one or two other states do. And in this one, I'm not aware of another state that is as opposed to these types of restrictive covenants, we call them. California is so against it, and I kind of like that. I think it's pro freedom, and I like the pro freedom, and at least in California, there's overall been respect in the courts of the confidentiality type clauses and protecting trade secrets. So that is your method in California to protect yourself and your trade secrets, including your customer list.
Amazing conversation. So many things that I didn't know that I just learned. And I so appreciate, Jay, you sharing your time and sharing your expertise and giving us some things that we need to think about when we are hiring. And, at one point we start with independent contractors, but at what time, do you really need to bring in people to work for you as an employee so you can have control on the information they're working on, and it's your, like Jay was saying, this is your copy, it's your IP, it's everything stays in-house because your employees are also in-house, right? So it's not outside. So I so appreciate Jay. And to get some feedback from Jay, make sure you follow him on the internet, on Facebook and LinkedIn. We're going to have his information inside of our workbook, our action planner that we're getting it to you. So make sure that you click there and connect with Jay. Also, he has a action step for you to do inside of the group so that he can give you some feedback. And do you want to explain to them what you want them to do, and also what is your free gift for them?
Sure. So the action step is I'd like you to share about, have you had any experiences with independent contractors that, where it got a little tense, a little iffy, a little bit challenging, and how did you work that out? How did it resolve? And for the giveaway, I would love to give you the opportunity to, you said the free giveaway? Yeah, the free giveaway, love you to see my 5 steps to, or 5 secrets to really protecting yourself, reducing your risk. And in fact, I think we touched on a little bit one of those today, and you really, I have yet to add to these 5 things. It encompasses everything you really need to protect your business and really understand how to keep yourself from getting sued. These are great things. And I just want to say for today, like your key takeaway too is, just make sure to really really use the best templates you have available to yourself, and make sure that you're not going to do anything that's like cutting and pasting and using what somebody else has, because that's going to put you in so much risk. And we touch on that, I think, in what we that free download you'll get.
Yes, yes. Oh my gosh. Thank you so much. I so appreciate Jay. And again, don't forget to connect with Jay in the group and on social media. Thank you.
Thank you.